Good evening, everyone. Since it's the last presentation of the day, we perfectly understand that we are all tired and we just want to end this conference and as quickly as possible. So we will try to make our presentation short and concise. So we would like to share the presentation. I hope you can see it right now.
We can see it coming. Yes, now we can see.
You see it right now? Great. So there are basically 5 issues that we would like to discuss. We would like to trigger some questions about these aspects of the application of Article 6 of the European Convention on Human Rights and Enforcement Proceedings. And the point of our presentation is not to give answers, but perhaps to trigger some questions which we have not found answers in legal doctrine and in the case law of the European Court on Human Rights. And particularly, we would like to focus on issues 4 and 5, which are liability for unfair enforcement proceedings and the problems of the application of Article 6 of the Convention to enforcement of arbitral awards. The first issue what we would like to discuss and questions that we would like to ask is what is the position of enforcement proceedings in general? If we analyze the member states of the European Convention on Human Rights, we can actually find various models. In some countries, enforcement proceedings are part of civil proceedings. In other member states, enforcement proceedings are regarded as an independent or public area of law. In other countries, a mixed approach is applicable when enforcement proceedings are regarded as a mix of private and public administrative law. In Lithuania, for instance, we believe that the third model has been established. Enforcement proceedings in Lithuania are regulated by the Code of Civil Procedure. However, there are a lot of public administrative acts which work like a supplement to the Code of Civil Procedure. So it's kind of mixed proceedings what we have. And these questions are not merely theoretical. They raise the questions of the application of human rights, to what extent human rights shall be applicable in enforcement proceedings. And perhaps the answer can be found in the practice of the European Court on Human Rights in the landmark case Hornsby versus Greece in 1997. The court found that Article 6, the right to a fair trial, is also applicable to enforcement proceedings. However, the court in this case and in the further case law did not answer the question. So what is the position of enforcement proceedings in the legal system? Is it part of civil proceedings or not? And the other question, which is open to this till this very day, is to what extent the guarantees of Article 6 are applicable in enforcement proceedings, because Article 6 has a lot of guarantees in the trial. However, what kind of guarantees can be applicable in the enforcement proceedings? The Council of Europe, in its opinion number 13 in 2010, just mentioned that affecting enforcement proceedings is an important rule of the rule of law in any member state, and just merely stated that enforcement proceedings must be implemented in compliance with the fundamental rights and freedoms of the Convention, including Article 6. However, neither in the practice of the Council of Europe nor in the case law of the European Court on Human Rights, there is no clear answer. So what principles, what guarantees of Article 6 shall be applicable in enforcement proceedings? We would propose that at least these 4 elements, which are fundamental principles of the right to a fair trial, should be also to some extent applicable in the enforcement proceedings. The reasonable length of enforcement proceedings, for instance, has been addressed in various cases by the European Court on Human Rights, and it's clear that this principle is applicable. However, when we talk about other aspects of the right to a fair trial, like involvement of the parties, equality of arms, and adversarial proceedings, it's debatable to what extent these principles are applicable. So these questions, I believe, should be addressed by the European Court of Human Rights in the further case law, but it's still open question. So to what extent these principles are applicable in enforcement proceedings? The other aspect what we would like to discuss is supervision of enforcement proceedings. So if we follow the case law of the European Court on Human Rights and we admit that Article 6 is to some extent applicable to enforcement proceedings, the question is, so who should actually guarantee that at least some principles of Article 6 of the Convention are applicable in enforcement proceedings? The problem with enforcement proceedings is that the involvement of the court, who is in general responsible for the application of Article 6 in the litigation, is very limited in enforcement proceedings. Usually the court works only for certain dispute settlement to very limited extent, and may issue some certain authorizations if necessary. So it means that in general it's the enforcement agent or the bailiff who is responsible for the supervision of the enforcement proceedings and has the duty to ensure the fairness of these proceedings.
Who is responsible for those rights enforceable in the enforcement proceeding? Is it's a responsibility of the states, or it's a responsibility of the private bailiff or so on?
Yes, this actually brings me to another slide which namely covers this issue. So really, who is liable for the convention? So is the state always liable? Because in different member states we have different nature of enforcement agents or bailiffs. In some member states enforcement agents work like private persons. In other states it's purely public person. A mixed model is also can be found in the member states. So can the state be liable for the actions, let's say, of the enforcement agent who works purely as a private enforcement agent? Some answer can be found again in the case law of the European Court on Human Rights and some international legal instruments, which is quoted, one of them in this slide. So the position is that even though the bailiff, the enforcement agent, works as a private person, he should be regarded as a public state body when we talk about enforcement proceedings. And perhaps this is the conclusion like this because of the importance of enforcement proceedings. They need to protect the fundamental rights like the right to property and so on. But this question is again still debatable, and the European Court on Human Rights in some cases has suggested that irrespective of what nature of enforcement agent is, the state has the burden to ensure the compliance with the final judgment, and this duty starts from the moment when the judgment becomes binding and enforceable. So this practice, again, it's still quite debatable. The European Court on Human Rights has not found very clearly in none of the cases where the state is always liable for misapplication of Article 6 by the private enforcement agent. However, the cases what we have analyzed so far, they seem to suggest that the state today should be liable even for those kind of actions. So is the state always liable? What circumstances may reduce or limit the liability, and how liability of the state for the violation of Article 6 may be changed due to the nature of the enforcement? For instance, when we talk about pecuniary judgments, enforcement of pecuniary judgments, that's quite obvious that the state can enforce judgment and to take certain measures. But when we talk about non-pecuniary judgment, then only the debtor, for instance, can perform the judgment and the debtor fails to do so for some reasons, can the state be always found liable for such actions? And the practice of the European Court on Human Rights suggests that, and it's kind of general rule, I would say, that the right to access to a court cannot oblige a state to have every single civil judgment executed, no matter what the judgment or the circumstances. So it suggests that actually there can be cases when the state can claim before the European Court on Human Rights that the state is not liable for the actions because it was the debtor who can only personally perform the judgment, or there were certain other aspects which may justify misapplication of Article 6 in the enforcement proceedings. And you can see the quotation from the legal scholars in this area that they agree that what the European Court on Human Rights reviews in such cases is whether the national authorities acted adequately and sufficiently. So still it suggests that the member state can justify misapplication of Article 6, and the question of liability of the state if Article 6 was actually breached in the enforcement proceeding is still open. The final issue that we would like to address very quickly, and the final slide of our presentation, is the problem of application of Article 6 of the Convention for enforcement of arbitral awards. To begin with this problem, I think we should remind ourselves that the nature of arbitration, of commercial arbitration, is a private agreement between the parties to settle the dispute in arbitration, not in the state court. And since arbitration is a purely private dispute settlement mechanism, there is usually no involvement of the state, but how the arbitration court is formed. There is no supervision by the state over the arbitral tribunal and so on. So the question arises actually, so if, let's say, after the arbitration court renders a judgment and the losing party fails to execute the judgment, so what remedy should be available for the winning party? It seems actually that if the parties agreed for an arbitration agreement, the logical conclusion would be that the winning party could claim for contractual liability of the losing party if the party fails to perform the agreement and fails to execute the award of the arbitral tribunal. The other thing is that the practice of the European Court on Human Rights is quite clear that an arbitration agreement is a waiver of the guarantees of Article 6 of the Convention. It means that the parties under the Convention are free to agree to go to the arbitration court instead of the state court and settle their disputes in the arbitration. So does this case law, can it justify the position, for instance, that since the parties waived their guarantees of Article 6 by concluding of an arbitration agreement, they also in this way have waived their guarantees of the application of Article 6 in the enforcement proceedings? Because it seems quite logical that if the persons did not want to go to the state court, we chose arbitration and we decided to waive this right. So the enforcement proceedings, which are always carried out by the state authorities, it seems that the parties also have waived of this right as well. Of course, all these questions are in very contradiction with the effectiveness of arbitration. Of course, arbitration without an effective enforcement mechanism of arbitral awards would be not as efficient as it is right now. However, these questions really are, to our understanding, really important. We have not addressed enough ideas in the legal literature, and it would be a very interesting case before the European Court on Human Rights if the state would say why we should guarantee the application of Article 6 if the parties made an arbitration agreement and one of them is not willing to accept the consequences of such agreement as well. The other aspect which is also important to note is that the state courts have a very limited supervision power over arbitral awards. Usually in various countries there are only a very limited aspects which the state court can analyze whether the arbitral award is lawful or not. So it's a limited supervision by the state court. And the final issue is that the actual enforcement of arbitral awards. We believe that in general, enforcement proceedings are organized for enforcement of namely state court judgments, which have certain criteria and certain requirements. But since there are no usually criteria for an arbitral award, the actual enforcement of such awards can be really problematic for the enforcement agents. So I think this concludes our presentation. And well, if you have any questions, we would be very glad to try to answer to them.